Good evening. Hello. Hello, everybody. Good evening. Just getting set up here. Just need another minute. We have a lot of things going on today. So here we are. I wanted to come on tonight and read through what's going on in the Garcia case. This is the case the Supreme Court ruled on today, giving until 5 o'clock tomorrow more time for the government to do what they need to do on this case. I thought, well, let's go ahead and read through the order that is in play right now. I have the order that was issued just yesterday regarding this situation in district court in the District of Maryland. So I thought I would just take you through. You have to forgive me here. I'm still getting used to being back here on TikTok. So I am on the tube Tuesday, Thursdays, and Sundays, and at 7 o'clock Central. But anything that's kind of like breaking news or something that's just happening today, I will be coming on TikTok to do lives on because it is really easy for me to jump on here and go through it. So this is an order again that was issued by a judge. Zinus, I guess, is how we'd say that, perhaps. And it was just issued on the 6th, and it has to do, of course, with Mr. Garcia, who was mistakenly sent to El Salvador. I will read through the decision, and then afterwards I will do a Q&A. I've got comments off now, just so that everyone can listen, so my moderators don't have to worry about trying to moderate while I am going through this. It's very important opinion here. So let me grab another pen here. Oh, here we go. All right, so we'll go ahead and get started then. We are in the United States District Court for the District of Maryland, and we've got our case number right here for anyone who's interested. The Court of Appeals and Supreme Court will have different numbers. This is the District Court. We have Mr. Garcia versus Ms. Noam, the Secretary of the United States Department of Homeland Security, and it's called a memorandum opinion. And just making sure I'm in frame properly. In 2019, an immigration judge acting under the authority delegated by the United States Attorney General and pursuant to powers vested by Congress granted plaintiff Garcia withholding of removal, thereby protecting him from returning to his native country, El Salvador. Such protection bars the United States from sending a non-citizen to a country where more likely than not, he would face persecution that risks his life or freedom. And then she's citing the INA, which is the Immigration Nationality Act here. 6 years later, without notice, legal justification, or due process, officers from U.S. Immigration and Customs Enforcement, ICE, a sub-agency of the Department of Homeland Security, put him on a plane bound for the Terrorism Confinement Center in El Salvador. And we have footnote 1 here, which states a citation to Fox News. Neither the United States nor El Salvador have told anyone why he was returned to the very country to which he cannot return, or why he is detained there. And there is footnote number 2 down here. Defendants did not assert at any point prior to or during the April 4th, 2025 hearing that Mr. Garcia was an enemy combatant or an alien enemy under the Alien Enemies Act, or removable based on MS. I'm going to censor myself just a bit here so that we don't get into trouble with the algorithm. Recent designation as a organization under 8 U.S. Code Section 1189, invoking such theories for the first time on appeal, cannot cure the failure to present them before this court. In any event, defendants have offered no evidence linking Garcia to this group or any other activity. And vague allegations of association alone do not supersede the express protections afforded under the INA, including 8 U.S. Code sections 1231B3A and 1229A and 1229B. That was our second footnote up here. All right, we do have a transcript quote that she has included. So I will read that. This is the exact date and time. Mr. Ruvani, quote, "We have nothing to say on the merits. We concede he should not have been removed to El Salvador," end quote. And then a transcript, quote, "What basis is he held? Why is he in El Salvador of all places?" asked the court. To which the government replies, quote, "I don't know. That information has not been given to me. I don't know," end quote, by the government. That silence is telling, as defendants acknowledge they had no legal authority to arrest him, no justification to detain him, and no grounds to send him to El Salvador. Let me have footnote 3 here. And then we're quoting filing. "Through administrative error, Garcia was removed from the United States to El Salvador." Quoting filing. "Through administrative error, Garcia was removed from the United States to El Salvador. This was an oversight," end quote. And then another quote by the government. "This person the plaintiff, Garcia, should not have been removed. That is not in dispute," end quote. "Let alone deliver him into one of the most dangerous prisons in the Western Hemisphere." Footnote 4 explains that. "Having confessed grievous error, the defendants now argue that this court lacks the power to hear this case, and they lack the power to order Garcia's return. For the following reasons, their jurisdictional arguments fail as a matter of law. Further, to avoid clear, irreparable harm, and because equity and justice compels it, the court grants the narrowest, dare say only, relief warranted to order that defendants return Garcia to the United States." Background. Tea break, everyone, just a moment. Bump this up just a little bit. There we are. Garcia was born and raised in Los Nogales, El Salvador. His family owned a small and successful ceria. For years, they were subject to extortion and threats of unalive by one of El Salvador's most notorious bad people. This group, the bad people, used Garcia as a pawn in its extortion, demanding that his mother give Garcia over to the bad people, and he and others in their family, or he and others in its family, would be unalived. Attempting to escape the bad people's reach, the family moved 3 times without success. To protect Garcia, they ultimately sent him to the United States to live with his older brother, a U.S. citizen in Maryland. Garcia lived in Maryland for many years without lawful status. In early 2019, while waiting at a Home Depot in Hyattsville, Maryland, to be hired as a day laborer, Garcia was arrested. The Prince George's County Police Department questioned him about bad people affiliation, but nothing came of it. He was then turned over to ICE custody. On March 29th of 2019, DHS initiated removal proceedings against Garcia pursuant to 8 U.S. Code sections 1182 sub A sub 6 sub A sub I. On April 24th of 2019, Abrego Garcia appeared before an immigration judge where he conceded his deportability and applied for asylum, withholding of removal and protection under the Convention against Pending resolution of the requested relief, DHS argued for Garcia to be detained in ICE custody. DHS relied principally on a singular unsubstantiated allegation that Garcia was a member of a bad people group. Footnote number 5 here. The evidence against Garcia consisted of nothing more than his Chicago Bulls hat and hoodie. and a vague, uncorroborated allegation from a confidential informant claiming he belonged to the Bad People's Western Clique in New York, a place he has never lived. Pending resolution of the requested relief, DHS argued for Garcia to be detained in ICE custody. DHS relied principally on a singular, unsubstantiated allegation, which I just read through. The IJ, so the judge, ultimately detained Garcia pending the outcome of his requested relief from deportation, a decision affirmed by the Board of Immigration Appeals. October 10th of 2019, following a full evidentiary hearing, the immigration judge granted Garcia withholding of removal to El Salvador pursuant to 8 U.S. Code Section 1231 sub B sub 3 sub A. As a matter of law, withholding of removal prohibits DHS from returning an alien to the specific country in which he faces clear probability of persecution. In Garcia's case, the immigration judge concluded that he was entitled to such protection because the bad people had been targeting him and threatening him with unalive because of his family's business. DHS never appealed the grant of withholding of removal, and so the decision became final on November 9th of 2019. DHS never appealed the decision. We've got a transcript here from the government. Quote, "The government did not appeal that decision, so it is final," end quote. Accordingly, as defendants have repeatedly admitted, they were legally prohibited from deporting Garcia to El Salvador. Another transcript quote from the government: "There's no dispute that the order could not be used to send Garcia to El Salvador." For the next 6 years, Garcia lived in Maryland with his wife and their 3 children. He complied fully with all directives from ICE, including annual check-ins, and has never been charged with or convicted of any crime. On March 12th of 2025, while driving home from work with his young son in the car, Garcia was stopped by ICE agents. The officers had no warrant for his arrest and no lawful basis to take him into custody. They told him only that his status had changed. He was first transported to an ICE facility in Baltimore, Maryland. Next, ICE agents shuttled him to a detention facility in Louisiana and La Villa, Texas. He was allowed a handful of calls to his wife. He said that he was told he would see a judge soon, but that never happened. 3 days later, on March 15th of 2025, without any notice, legal process, or hearing, ICE forcibly transported Garcia to the confinement center in El Salvador, a notorious supermax prison known for widespread human rights violations. On that day, 2 planes carried over 100 aliens to the prison, purportedly pursuant to the Alien Enemies Act, the legality of which is the subject of separate litigation. A 3rd plane included aliens with Title VIII removal orders. Many of them were in ICE custody awaiting asylum and other protective hearings in the United States. Once the planes arrived in El Salvador, the male detainees, and then we've got a footnote 7 here, female detainees were returned to the United States because the prison would not accept them. Once the planes arrived in El Salvador, the male detainees were stripped and shackled, their heads were shaved, and they were marched into the prison to join nearly 40,000 other prisoners held in some of the most inhumane and squalid conditions known in any carceral system. Since then, no one has heard from Garcia. To effectuate a mass relocation of those detained by the United States, the federal government struck an agreement with El Salvador whereby it would pay the Salvadorian government $6 million for placement of the detainees in very good jails at a fair price that will also save our taxpayer dollars, end quote, Marco Rubio. El Salvador's president, Nayib Bukele, has publicly touted the agreement terms. "We are willing to take in only convicted criminals, including convicted U.S. citizens, into our mega prison in exchange for a fee." Footnote 8. It's unclear what qualifies as a convicted criminal under the terms of the agreement, but Garcia has not been convicted of any crime. According to a memorandum issued by El Salvador's Ministry of Foreign Affairs, the agreement provides that the detainees will be held for 1 year pending the United States' decision on their long-term disposition. After Garcia was transferred to the prison, defendant DHS Secretary Kristi Noem personally toured the facility alongside senior Salvadorian officials. From inside the prison walls, Secretary Noem declared that transferring individuals previously detained on U.S. soil to the prison remains one of the tools in the United States toolkit that we will use if you commit crimes against the American people. Although the legal basis for the mass removal of hundreds of individuals to El Salvador remains disturbingly unclear, Garcia's case is categorically different. There were no legal grounds whatsoever for his arrest, detention, or removal, nor does any evidence suggest that Garcia is being held in that prison at behest of the Salvadorian authorities to answer for crimes in that country. Rather, his detention appears wholly lawless. Based on these events, Garcia, through counsel and along with his wife, Jennifer, and their son, AAV, by and through his mother and next friend, footnote 9 here, which is Sura, and AAV's claims are not the subject of this decision, and so for clarity, the court refers only to plaintiff Garcia. And next friend filed suit in this court on March 24th of 2025 against DHS Secretary Noem. Acting Director of U.S. Immigration and Customs Enforcement Todd Lyons, Acting Executive Associate Director of ICE Enforcement and Removal Operations Kenneth Genalo, ICE Baltimore Field Officer Director Nikita Baker, Attorney General Pamela Bondi, and Secretary of State Marco Rubio, collectively the defendants. Garcia specifically alleges that his removal to El Salvador violated the Immigration and Nationality Act 8, the U.S. Code Sections 1213 sub B sub 3 sub A count 1, the Due Process Clause of the Fifth Amendment for count 2, and the Administrative Procedure Act 5 U.S. Code Section 706 sub 2 count 3, and pleaded in the alternative qualifies him for a habeas relief pursuant to 28 U.S. Code Section 2241, Count 5. The matter is now before the court on plaintiff's motion for preliminary injunction, following full briefing and a hearing held on April 4th of 2025. This memorandum opinion sets forth the court's findings in support of the order entered on April 4th of 2025. Number 2, jurisdictional challenges. The defendant's only meaningful challenge to the motion is that this court lacks the power to hear this case. They advance 3 arguments. The court considers each in turn. A, the court lacks jurisdiction because the core of the claims sound in habeas. Defendants first argue that because Garcia challenges his confinement in prison, the core of his claims sound only in habeas brought pursuant to 28 U.S. Code Section 2241. Citing the DHS case, quote, habeas is the appropriate remedy to ascertain whether any person is rightfully in confinement or not, end quote. And as such, suit is proper only against the immediate custodian, so the warden of the prison there, and in the jurisdiction where Garcia is confined, El Salvador. Defendants are wrong on several fronts. Garcia exclusively challenges his lawless return to El Salvador, not the fact of his confinement. This is the core of his claim, as defendants concede, which is why his suit would remain equally strong had defendants released Garcia to the streets of El Salvador instead of the prison. Citing case law here, citing the JGG case, everyone, that's the other massive El Salvador case. As defendants did in JGG, And they fundamentally ignore the difference between challenging legality of a removal as opposed to confinement. And we have footnote 10 here. In this context, habeas claims need not be brought to the exclusion of all other claims. And then she's citing law for that. For purposes of this decision, however, Garcia simply does not challenge his confinement. The removal itself lies at the heart of the wrongs. Thus, the court need not wade into the murky jurisdictional implication that flow from such a challenge. But even if the court considers the thorny question of custody as it pertains to Garcia's habeas claim, count 5, the defendants are not out of the woods. They do indeed cling to the stunning proposition that they can forcibly remove any person, migrant, and U.S. citizen alike to prisons outside the United States, and then baldly assert that they have no way to effectuate return because they are no longer the custodian and the court thus lacks jurisdiction. As a practical matter, the facts say otherwise. The facts are that the United States exerts control over each of the nearly 200 migrants sent to the prison. The defendants detained them, transported them by plane, and paid for their placement in the mega jail until the United States decides their long-term disposition. Footnote 11 here states, a citation to the Associated Press here. Against this backdrop, defendants have produced no evidence to suggest they cannot secure one such detainee, Garcia, for return to the United States. Equally important to credit defendants' argument would permit the unfettered relinquishment of any person, regardless of immigration status or citizenship, to foreign prisons for pennies on the dollar. Footnote 12. A citation to Fox News. Nor do the defendants cite any authority to support this eye-popping proposition. Sure, they point to the court in Munaf v. Green, but that decision has little bearing here. In Munaf, the court reviewed whether plaintiffs, American citizens, who voluntarily traveled to Iraq and were subsequently detained for violations of Iraqi law, could challenge their detention. The court concluded that while the district court retained jurisdiction in the first instance, the merits of the habeas challenge failed because, quote, Iraq has the sovereign right to prosecute Omar and Munaf for crimes committed on its soil, end quote. Here, by contrast, Garcia is not being held for crimes committed in or against El Salvador, the United States, or anywhere else for that matter. His claims do not implicate any question of competing sovereign interests, and so Munaf offers little guidance. And then we have footnote 13. Defendants also urge this court to follow Kiemba v. Obama, wherein the United States Court of Appeals for the District of Columbia held that a claim could not sound in habeas where the plaintiff sought relief to avoid torture in the receiving country. The Kiemba court held that because the district court may not question the government's determination that a potential recipient country is not likely to torture a detainee, the habeas claim fails on merits. Citing Munaf, this is not this. That is not this. Defendants have already determined that Garcia must not be returned to El Salvador because he had established under the INA that he faces persecution from bad people. Defendants remained bound to that decision just as much today as they were when they decided not to appeal that determination. Defendants' violation of the INA in detaining Garcia in El Salvador does not implicate United States' policy decisions as to El Salvador's possible propensity to violate the Convention against the T word writ large. This court should defer to defendants' determination that Garcia will not likely be a torture deed or unalived in El Salvador, this implicating executive policy decision. Accordingly, Kiemba does not counsel a different outcome. Thus, while the Success of Garcia's preliminary injunction motion does not depend on the success of his habeas claim. Defendants also fail to convince this court that the claim will not survive in the end. For purposes of this decision, suffice to say, the court retains jurisdiction because Garcia challenges his removal to El Salvador, not the fact of confinement. B. Redressability. Defendants next make a narrow standing argument contending that because the claims are not redressable, this court lacks the power to hear the case. Federal courts are the ones of limited jurisdiction, hearing only live cases and controversies. A party's standing to maintain an action is an essential and unchangeable and unchanging part of the case or controversy requirement of Article 3. To satisfy Article 3 standing, the plaintiff must make plausible that he, 1, has suffered an injury in fact, that is A, concrete and particularized, and B, actual or imminent, not conjectural or hypothetical. 2, the injury is fairly traceable to the challenged action of the defendant. And 3, it is likely, as opposed to merely speculative, that the injury will be redressed by a favorable decision. Citing Friends of the Earth, Inc. here, the defendant's redressability argument, simply put, is that their placement of Garcia in an El Salvadorian prison deprives them of any power to return him. Thus, they say, even if Garcia succeeds on the merits, defendants are powerless to get him back. The facts demonstrate otherwise. First, defendants can and do return wrongfully removed migrants as a matter of course. This is why in Lopez Soto v. Garland, the Fourth Circuit concluded that the defendants could redress wrongful removal to El Salvador by facilitating the plaintiff's return per DHS's own directives. Citing the Enkin case, aliens who are removed may continue to pursue their petitions for review, and those that prevail can be afforded effective relief by facilitation of their return, along with restoration of the immigration status they had upon removal. Second, defendants unilaterally placed hundreds of detainees behind the walls of the prison without ceding control over the detainees' fate, as the detainees are in the prison pending the United States decision on their long-term disposition. Citation here, unlike Garcia, for whom no reason exists to detain him, defendants transported many individuals who had been detained in the United States while awaiting immigration proceedings. Footnote 14 here is a citation to the declaration of SZFR, a female detainee formerly held at a center in Texas awaiting a merits hearing on her asylum claims, was part of the mass transport to that prison, but ultimately returned to the United States because El Salvador would not accept females. We also have the declaration of an immigration attorney for Romero, who had been detained at another center pending his asylum hearing, at time was transported to the prison. A declaration of an immigration attorney for detainee GTB, a native of Venezuela who had been detained at another facility awaiting deportation proceedings when transported to El Salvador without warning. ICE ultimately returned her to the United States. A declaration of immigration attorney for detainee Barrios, who had been housed at another detention center awaiting hearing on protected status prior to transportation to El Salvador. Declaration of immigration attorney of detainee EV, who had been housed at another processing center in Pennsylvania awaiting hearing on final order of removal when transported to El Salvador. Declaration of immigration attorney for detainee JABV, who had been detained domestically prior to his removal hearing scheduled for April 7th, was transported to El Salvador. Declaration of immigration attorney for detainee LG, who had been detained at another processing center in Pennsylvania awaiting removal proceedings prior to transfer to El Salvador. Here. All right, that was a long footnote, everyone. And back up we go. That was number 14. So she's citing here to all of the declarations, which are basically sworn statements of multiple attorneys. Yet, despite defendants' power to transfer those awaiting hearings to El Salvador for a good price, defendants disclaim any ability to secure their return, including Garcia. Surely, defendants do not mean to suggest that they have wholesale erased the substantive and procedural protections of the INA in one fell swoop by dropping those individuals in in El Salvador without recourse. Instead, the record reflects the defendants have outsourced part of the United States' prison system. Footnote 15 here. Quoting citation from defendant Noam, quote, "This facility is one of the tools in our toolkit that we will use." And then another citation to when she said that. Thus, just as in any other contract facility, defendants can and do maintain the power to secure and transport their detainees, Garcia included. In the end, defendants' redressability argument rings hollow. As their counsel suggested at the hearing, this is not about defendants' inability to return Garcia, but their lack of desire. Quote, the court, "Can we talk about then, just very practically, why can't the United States get Mr. Garcia back?" Government, Your Honor, I will say for the court's awareness that when this case landed on my desk, the first thing I did was ask my clients that very question. I've not received to date an answer that I find satisfactory, end quote, from the government's attorney. Flat refusal, however, does not negate redressability. The record reflects that the remedy is available. Garcia maintains standing to sue. C. Section 1252G of the INA does not strip the court's jurisdiction in this case. Lastly, defendants argue that 8 U.S. Code Section 1252 sub G deprives the court of jurisdiction to review this matter. The statute reads, "Except as provided in this section, notwithstanding any other provision of law, statutory or non-statutory, including Section 2241 of Title 28, or any other habeas corpus provision, the Sections 1361 and 1651 of such title, no court shall have jurisdiction to hear any cause or claim by or on behalf of any alien arising from the decision or action by the Attorney General to commence proceedings, adjudicate cases, or execute removal orders against any alien under this chapter." Defendants concede that Reno v. American Arab Anti-Discrimination Committee commands a narrow construction of Section 1252G, limiting application solely to the Attorney General's exercise of lawful discretion to 1, commence proceedings, and 2, adjudicate cases, or 3, execute removal orders. Quote, "It is implausible that the mention of 3 discrete events along the road to deportation was a shorthand way of referring to all claims arising from deportation proceedings." Citing Borwin, quoting here, noting that Section 1252G only stripped federal courts of jurisdiction to review the Attorney General's decision to exercise her discretion to initiate or prosecute the specific stages in deportation process. As the Reno court explained, quote, "There was good reason for Congress to focus special attention upon and make special provision for judicial review of the Attorney General's discrete acts, which represent the initiation of prosecution of various stages in the deportation process. Thus, this court is deprived of jurisdiction only for the discretionary decisions made concerning the 3 stages of the deportation process." And then she's citing 1, 2, 3, 4, 5 cases. Let's make sure, yes, just 5. Defendants press that Section 1252G precludes jurisdiction here because the claims concern defendant's execution of his removal order. The argument fails in both fact and law. First, the court cannot credit the defendant's removal of Garcia pursuant to an executed removal order under the INA. Defendants have not produced any order of removal as to Garcia, executed or otherwise, or submitted any proof that they had removed him pursuant to one. Citing the transcripts again, counsel admitting no order of removal is part of the record. Counsel confirming that the removal order from 2019 cannot be executed and is not part of the record. Nor have any other colliery documents surfaced, such as a warrant for removal, deportation customarily served on an alien as part of a lawful deportation or removal. Here she's citing to a sample warrant for removal, just to give an example of what that would look like. From this, the court cannot conclude that Garcia was spirited to El Salvador on an executed removal order, such that Section 1252G is implicated. Second, even if there were an executed order of removal for Garcia, his claims do not seek review of any discretionary decisions. He's not asking this court to review the wisdom of the Attorney General's lawful exercise of authority. Rather, he asks that the court determine whether his return to El Salvador violated the INA. In this circumstance, the Fourth Circuit has spoken. Bowrin made plain that review of agency decisions involving pure questions of law do not fall into any of the three categories enumerated in Section 1252G. The Bowrin court emphasized, quote, does not apply to all claims arising from deportation proceedings because Section 1252G stripped the federal courts of jurisdiction only to review challenges to the Attorney General's decision to exercise her discretion to initiate or prosecute these specific stages in the deportation process. Citing case law here, we've got Hovespian. The district court may consider a purely legal question that does not challenge the Attorney General's discretionary authority, even if the answer to that legal question forms the backdrop against which the Attorney General later will exercise discretionary authority. Citing for the case law here, this is the Siahan case. To insist, as the respondents do, that this court lacks jurisdiction because of Section 1252G to determine the purely legal question of whether his removal under these circumstances violates the statutory and constitutional provisions that his habeas petition has raised, runs contrary to the consistent rulings of the Supreme Court for the last 20 years. Accordingly, and after exhaustive analysis, Bowrin concluded that absent express congressional intent to eliminate the general federal habeas corpus review pursuant to 28 U.S.C.A. Section 2241, the remedy remains available to Bowrin and other aliens similarly situated. So this is the precedent that she is citing here. Like Bowrin, Garcia presents to this court a pure question of law, whether defendants exceeded their authority in returning him to El Salvador in violation of 8 U.S. Code Section 1231 sub B sub 3 sub A. In this court's view, no plainer question of statutory interpretation could be presented. Thus, Section 1252G does not deprive the court of jurisdiction over the claims. In sum, the court retains jurisdiction over this case, and even though defendants concede that if this court retains jurisdiction, Garcia prevails on the merits of his preliminary injunction, for the benefit of all, the court briefly addresses why this concession makes sense. We have footnote 18 here, which again, she is citing the transcript. Quote, government attorney here, if you're not buying our jurisdictional arguments, like we're done here, we have nothing to say on the merits, end quote. That's not a good sign when an attorney is saying that. Number 3, merits of preliminary injunctive relief. So everybody, I have spent just countless amounts of time going through the elements for preliminary injunctions, including the test and all of the elements of the test. So I am going to skip through this piece because it's an analysis that we're going to see over and over and over again, whether or not he was entitled to a preliminary injunction. And that's really not the issue that's at play in front of the Supreme Court. But here are the elements needed for the test. First, a likelihood of success on the merits is the first element. And so she goes into if she thinks that that will happen. And then irreparable harm, or irreparable harm, balance of equities and public interest. This should sound very familiar because these are, again, the elements to the test for a preliminary injunction. All right, so we will go into, I think, the last couple of paragraphs that she sets out regarding public interest, I think, are important. So I will read into that, and then we have the conclusion. I will open comments up, all right? Balance of equities and public interest. This is the last element needed in the test for a preliminary injunction. The court considers the last two factors in tandem because the balance of equities and public interest merge when the government's the opposing party. As to the balance of the equities, courts must balance the competing claims of injury and must consider the effect on each party of the granting or withholding of the requested relief. That is the Winter case. Again, I have put up a post going through these elements and citing the Winter case. That's a very important case for these administrative suits. When considering the public interest, the court should pay particular regard for the public consequences in employing the extraordinary remedy of injunction. The court is mindful that it may not collapse this inquiry with the first Winter factor, going into case law explaining that it's a circular reasoning to argue that the government program is against the public interest because it's unlawful, and that such argument is nothing more than a restatement of their likelihood of success. Quote, of course, there is public interest in preventing aliens from being wrongfully removed, particularly to countries where they are likely to face substantial harm. Quoting the Enkin case, equally important, the public remains acutely interested in seeing its governmental institutions follow the law. Seems like it should be important. And then, let me make sure here I'm in frame, everyone. The absence of injunctive relief places this interest in greater jeopardy, as demonstrated by Garcia's experience over the past 3 weeks. Defendants seized Garcia without any lawful authority, held him in 3 separate domestic detention centers without legal basis, failed to present him to any immigration judge or officer, and forcibly transported him to El Salvador in direct contravention of the INA. Once there, U.S. officials secured his detention in a facility that, by design, deprives its detainees of adequate food, water, and shelter, fosters routine violence, and places him with his persecutors, the bad people. In short, the public interest and companion equities favor the requested injunctive relief. Footnote 19 here. Defendants suggest in their response that the public retains an interest in not returning Garcia to the United States because, quote, he is a danger to the community, end quote, only to abandon this position at the hearing, again with no good reason. No evidence before the court connects Garcia to bad people or any other criminal organization. Conclusion. Based on the foregoing, the court retains jurisdiction to hear this case. Garcia has also demonstrated he's entitled to the injunctive relief sought. The court's April 4th order thus remains in full force and effect. Footnote 20. For these same reasons, the court denies defendants' motion to stay the court's April 4th order. And then it is signed here by the judge. With that, they did appeal to the U.S. Supreme Court, and the U.S. Supreme Court has moved the deadline from midnight tonight until 5 p.m. tomorrow. So let me go ahead and turn on comments, everybody. Please be respectful. Happy to do a Q&A, but please be respectful. Thank you very much. Appreciate that. All right, there we go. Oh, there we are. Hello, everybody. Welcome in. Hello. Yes. Let me move this so we can see the comments a bit better, everyone. Here we go. Really appreciate you. Oh, absolutely. Oh my gosh. This is absolutely one of the most horrific situations here. So he was denied asylum before. So it looks like he was given this. Let me use the exact terms because we've got a couple of different roads that we go down here. But I want to make sure my terminology is exactly right. So hold on one second. All right, let me make sure I find the exact. Full evidentiary hearing here. All right. Withholding removal proceedings prohibits DHS from returning an alien to the specific country in which he faces clear probability of persecution. So the judge concluded he was entitled to the protection because of the gang, and the gang was targeting him. So he was given full withholding of removal. That's what he was awarded. Now, as far as the asylum goes, that I don't know specifically. Tea break, thanks, Grandma. Yeah, I didn't. Thanks, Grandma. Lagging hard. No, go out and come back in. Go out and come back in. Yeah, I mean, it was 2019, so that's kind of the... Supreme Court lifted the block, removing the Venezuelans? You'd have to be more specific. Did they, because the, did they lift the Enemies Act? Is that what you're saying? What? I don't know about that. I don't know about that. Just happened? Are you kidding me? Oh my goodness. Are you flipping kidding me? Lifted that. Hold on, everybody. Hold on. Oh my goodness. Oh my gosh. Really? Are you sure? Hold on. Hold on. Let me pull it. If that's true, we're in some trouble, people. We are in some trouble. Trouble! Trouble in River City. All right, hold on here, everybody. Enemies Act. Supreme Court. Gosh, I tell you what, I bet it was Alito. That Alito, I tell you what. Supreme Court. Seriously. Supreme Court allows Trump to enforce the Alien Enemies Act. What? For rapid deportations. Wow. Oh my gosh. Hold on. Let me read. Let me read it. Hold on, everybody. Oh my gosh. Oh my gosh. Are you freaking kidding me? Oh my goodness gracious. All right. So they made clear in an unsigned order the officials must give migrants subject to the Alien Enemies Act adequate notice that they're being removed pursuant to the Wartime Authority. So they have time to bring habeas. Now, hold on, everybody. Hold on. Wait a minute. Hold on. I need to pull the case up. That's not, they are not saying that law is lawful. Wait a minute. That is not what they're saying. Hold on, everyone. Wait. Hold on. I'm trying to get over here. Just a minute. Oh my gosh. All right. So, hold on. U.S. Supreme Court. I'm trying to get the exact language because it doesn't look like they're ruling that the law is appropriate. They're ruling on the notice issue. Sorry, everybody. I have my laptop like in my lap right now. Ruling. Supreme Court. JGG case. All right, hold on here. Here we go. Hold on just a minute. We'll go there. Was written badly. I just read it. Okay, hold on. All right, here we go. All right, just a second. I got it. Per curiam, Supreme Court of the United States, 24A 931. Trump, on application to vacate the orders issued by the United States District Court for the District of Columbia. All right, let me just read this here quick. This matter concerns the detention and removal of Venezuelan nationals believed to be members of whatever, an entity the State Department's designated as bad. The president issued proclamation such invoking the Alien Enemies Act to detain and remove Venezuelan nationals who are members of the bad group. Invocation of the act regarding the invasion blah, blah, blah. 5 detainees and a putative class sought injunctive and declaratory relief against the implementation of and their removal under the proclamation. Initially, the detainees sought relief in habeas, among other causes of action, but they dismissed their habeas claims. And they had to do that because of the rules when it came to recognizing a class. So we'll just make note of that here, everyone, before we go too far here. Okay, here we go. I'm printing it as I'm reading it, everyone. All right. All right, on March 15th, District Court for the District of Columbia issued 2 temporary restraining orders preventing any removal of the named plaintiffs and preventing removal under that act of provisionally certified class consisting of all non-citizens in U.S. custody who are subject to the proclamation. Right. The D.C. court denied the government's emergency motion to stay the orders. The government then applied to this court seeking vacatur of the orders. We construe the TROs as appealable injunctions. Man, this Supreme Court, they've got a problem here. If they're going to turn every single restraining order into an injunction, like we got trouble in River City. I mean, you can't just do that. That just happened yesterday, too, in another case. We grant application and vacate the temporary restraining orders. The detainees seek equitable relief against the implementation of the proclamation, against the removal. They challenge the government's interpretation of the act, right? They do not fall within the category, right? But we do not reach those arguments. Challenges to removal here must be brought in habeas. All right, fair. The detainees also sought equitable relief against summary removal, although judicial review. Hold on, it just printed. Just a minute, everyone. Okay, part 2, everyone. Part 2. Yeah, go on out and then come on back in, everyone. All right, part 2. So let's see what's going on. Oh, we've got Kavanaugh concurring. Listen to me, I'm shocked. Shocked. This is my shocked face. All right, so grant application. This is questionable. Hold on, let me get my pen here. We do not reach those arguments, so they're just ruling on the temporary restraining orders. All right. They're not ruling on the act itself. They're saying it has to be brought in a habeas order. Deportation, right. Regardless of whether detainees, right. So removal claims, right. I'm fast forwarding everybody because I'm just wanting to tell you what it means. The detainees are confined in Texas, so venues improper in the District of Columbia. As a result, government's likely to succeed on the merits. Interesting. Equitable relief, okay. It's limited. We've had held individuals subject to detention. Okay, to judicial reviews, questions of it, right. We got the Ludecky case, right. Rights against summary removal are not currently in dispute. Right. Oh my gosh, this is actually not bad, everybody. The government expressly agrees, right? Subject to removal, blah, 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 blah. Okay, so hold on, everyone. The Supreme Court is saying that they're entitled to due process. Let's hold on a minute, all right? I almost fell out of my chair. Everyone is like, the Alien Act's okay, you can deport all the Venezuelans. I'm like, I fell out of my chair. No, hold on. No, that's not what they're saying here. No, my goodness. Oh my gosh, okay. Here, hold on. The Fifth Amendment entitles aliens to due process of law in the context of removal proceedings. So the detainees are entitled to notice and an opportunity to be heard appropriate to the nature of the case, right? So they must receive notice after the date that they're subject to removal. The notice is afforded within a reasonable time and in such a manner that will allow them to actually seek habeas relief in the proper venue before removal occurs. Okay. For all of the rhetoric of the dissents, today's order and per curiam confirm the detainees subject to removal orders are entitled to notice and an opportunity to challenge the removal, right? The only question is which court will resolve the challenge. For these reasons, the whole venue lies in the district of confinement, which was a question in the JGG case. Sorry, puzzle piece, everybody. Hold on here. There we go. Dissents would have the court delay resolving the issue, requiring, given our decision today, the process begins anew down the road. We see no benefit. So application to vacate the orders. So presented and by him referred is granted. All right. So, okay. So it's so ordered. We have a concurrence. Let's take a peek here. Let's take a peek. We've got Kavanaugh concurring, saying he agrees, but I want to look quick and see if Kavanaugh says there shouldn't be any due process. Let's just look for a second. Again, hot off the presses, everybody, venue question. So he's talking about venue here. And this was the case that we just went through. Habeas and transferring claim. Okay, so Kavanaugh just wants to talk about venue issues. And then we've got Sotomayor, Kagan, and Jackson, and Barrett. Oh, that's not going to be good. Oh, dear. All right, and then we do have a dissent. So the court's legal conclusion is suspect, which I agree with. I would agree. Granting extraordinary relief here. Let's just make sure. What's bothering me, everyone, is that our temporary restraining orders are being changed into injunctions when the Supreme Court gets them. So they just take us through the history here. And so they're saying basically the proclamation isn't appropriate, and this was kind of all done under the cloak of night. The emergency wasn't at the level they were talking about that the government should have had. And then they're chastising the government for moving so quick. Compliance is an issue. The government's not really complying with the DC court. The prison's really bad. Extraordinary harm. Here we go. I simultaneously sought permission. So even as they're debating whether or not it's constitutional, they're still trying to ship people over there without any, acknowledging, hey, we could be shipping them over illegally. They don't care. They still want to keep doing it, which is like, the Garcia situation apparently doesn't mean anything. So begin with that upon which all 9 members of the court agrees. The court's order today dictates in no uncertain terms individuals subject to detention and removal under the act are entitled to judicial review. As to the questions of interpretation and constitutionality of the act, well, that's debatable. All right, so, and then they're also, wow, she's still going on here. She's still going on and on and on. So I'm not going to read through their entire dissent, because I want to take my time. I'm going to need to pop some popcorn and make sure I get all my highlighters going. Right. So let's talk about this, everybody. Let's talk about it for a minute. All right. Ooh, okay. Temporary restraining order. All right. So TRO has a test that's involved on whether or not everything is restrained. So a restraining order is going to have some kind of exigency to it. It's exigent. We need it right now, immediately. A preliminary injunction means we're going to stop it until, we get it through court. So this is like the immediate, 48 hours, get her done, versus the preliminary injunction where you're going to have an evidentiary hearing typically to show evidence on both sides and do the full dog and pony show. And they're like, okay, let's put this in place until we get it all the way through the courts. All right. And there's also a test for the preliminary injunction. But this is more of this is the second step. Sometimes a TRO can turn into a preliminary injunction, but the TRO, the key is going to be the timing on it. It needs to be immediately done. Meanwhile, the preliminary injunction's kind of bouncing around a little bit. Can we call the Supreme Court? What do we do? Okay. Let me explain what's happened here, everyone. All right, let me just explain this is a legal stuff that's happened. There's so many things going on in the JGG case. The biggest issue in the JGG case, all right, in JGG, which is the case brought by the 5 people in the class, under the Alien Enemies Act, all right, so under that act, there's no due process. There's no due process. And so that's the problem, is they just pick people up and put them on the plane and ship them out. There's no due process under the act. What the court is saying today, what SCOTUS is saying today, is that they have a right to habeas, meaning they have a right to due process. So people can't just be picked up and shipped to El Salvador. They have to be given notice and an opportunity to be heard. Now, whether or not the law is being used legally or not, or whether it's unconstitutional, that's a different question. But what they're saying is you cannot just pick people up off the street and ship them to El Salvador. All right? Now, there's a lot of legal questions that are at play, like it was a temporary restraining order. Does the Supreme Court even have jurisdiction over that? And Justice Jackson, she kind of ripped a new one on them yesterday, saying this isn't how we're supposed to be doing things here. And meanwhile, they're like, we don't care. We're going to call it a preliminary injunction because it, has that essence to it. And we can make determinations on preliminary injunctions. And that's what the court's doing. So they're claiming a jurisdiction that half of the court doesn't agree with. They should not have even heard this, is what half of the court's saying. And then they're saying, again, we're not ruling on the constitutionality or use of this act. What we're ruling on is habeas needs to be used. And so there's the issue. Will they appeal? There is no appeal. There's no appeal. Yeah, there's no appeal. The Supreme Court has set it out. Here's the key. Here's the trick of it, everybody. So everyone involved in the JGG situation, they are given notice and an opportunity to be heard, and in Texas. So, good luck wherever. Oh my gosh. At least there's that, an opportunity to be heard. So before you get shipped to El Salvador, you do get this chance to file a habeas petition. Habeas corpus means you are being unlawfully detained and you want the court to review your case. What the SCOTUS is doing here is giving jurisdiction to the place where you are at. So that was another big question in the JGG case, is where exactly do we have jurisdiction? Is it in DC or is it in where you're being held? And what the court said today is it's where you're being confined. That's where jurisdiction is. So you can file a habeas saying, I need the court to review this before you ship me to El Salvador, and you would file it in your jurisdiction. This, by the way, is not legal advice. This is legal information interpreting a court decision here, all right? Not making constitutional, right? No, there's no, there. Oh, wait, hold on. Wait a minute, Boxer Mom. Wait a minute. What? They're not making the Constitution null and void. No, no. This is an academic exercise. Now, the reason why we had to have that restraining order put into place immediately in the DC case, right, the JGG case, is they're just picking people up left and right and putting them in planes and shipping them over, right? So the judge is like, okay, stop that immediately. Stop it. There's a lot of things at play. The most important is there's no due process. There's been no due process under this act. So right now, the court's saying we have to have due process. We have other things we also need to have, but we have to have due process. I'm not saying it's a good decision or that I support the decision, but it's the legal decision from the Supreme Court saying you cannot just put them on a plane and ship them away. You have to give them notice and judicial review or an opportunity to be heard. It doesn't matter if you are a citizen or not a citizen. Your citizenship status does not matter. You have to be given due process. And the Supreme Court is saying that. And that's why they rushed this decision out, apparently, is what the majority is claiming. They're saying, well, we want to get this out there so people know the jurisdiction to file their habeas in and that they have a right to habeas. So that's why they're just shooting this out from the hip, today. Meanwhile, in the dissent, they're saying we shouldn't even have jurisdiction here. The lower court's temporary restraining order is not an injunction. And if you look at what's actually going on here, there might be some bad faith stuff going on, which is what we're seeing in the contempt arguments as well. All right. So as I've continued to lecture on that, I haven't been looking at the comments. Apologies. Here we are. All right, so are all of those people in El Salvador being returned immediately? No. Nobody's being returned immediately. One person should be returned immediately and is not being returned. Is this the court's way of enforcing 18 USC 1252? Right, the habeas corpus element. Right, that's what they're looking at here. They're saying you have a right to be heard in court. Now, due process to be heard, that's what we're talking about when we're talking about habeas corpus. Not considered cruel and unusual punishment. Good question, Heather. And that'd take about 6 years to get through the court system. How do they enforce their return? Great question, and we're going to find out. Do you know if these people in prison are serving a sentence for a crime? We do not know that. We don't have any of that information. The government has not shared that. This might slow them down from being sent. Yes, exactly, Barbara. That's exactly right. This is going to slow this whole process way down, which is the key to everything right now, everyone, is to slow it down. And also what the judge in DC was saying, he wasn't coming in and saying like, oh my gosh, this is so crazy, you just lit the Constitution on fire. He was saying, dude, we've got procedures, follow procedures, walk through the procedures and do it correctly. That's what he was saying. And, you know, we find ourselves saying that quite a bit with law enforcement in general, like they're rushing around, rush. And meanwhile, in the legal system, we don't rush anything. We're like, hold up, man, do it right, do it correct the first time, and then you don't have to run it through all of these appeals so many times. Okay, all right. What will this mean for Mr. Garcia? Oh, I don't think it'll mean anything for Mr. Garcia. Mr. Garcia is his own creature. Mr. Garcia's case is going to be, this generation's, what's the phrase I'm looking for here? When you think of the, I'm having a hard time saying certain things here on the talk. This is going to go down in history. This is one of those monumental historical moments in the legal field that will be like you're going to remember where you were when the decision gets made on this case. All right, you're going to know. It's one of those moments. Like you knew when they said that there were Americans trapped in a Middle Eastern country, right? Back in the, Contra days, you remember where you were. So this is going to be one of those. That's how significant the Garcia case is. Yes. I mean, it's exactly. It's incredibly important. OJ in the SUV. Yes. Rodney King. Yes. Exactly. One of those moments where the U.S. has screwed up so bad, so incredibly bad, that it will leave its mark in your memory. That's what we will have here. If Mr. Garcia is deceased, it's going to be a really awful situation. What happens next in JGG? Right now, we're waiting on the court to give an order on the hearing to show cause that just occurred on Friday. So he said he would have an order out to us early this week, deciding whether or not we've got some contempt issues going with the government. So we're waiting on that. We can't get Garcia back. That's the question. That the Chief Justice has said government needs to respond by 5 p.m. tomorrow. Here, we're in a situation where they're like, you need to get her done like right now before midnight. So he's pushed it a little bit further. Emergency docket today with Roberts. Oh, really, VC? Has the order come out? Oh my gosh. Yeah, I'm going to have to do that. So I started with the reading of the Garcia situation and then just came out here with the JGG. Is this the one you're talking about? Because I just read through the per curiam that was issued. Okay. Yeah, so right, that's what we've been talking about. Let me move my note out of the way. I'm pointing to it and everyone's like, I can't see what you're pointing to. I've got to work on it. Right, so here it is right here. Trump v. JGG. This is the per curiam decision that was just issued by the U.S. Supreme Court. All right, and what they have done is they have eliminated the restraining orders from the lower courts, but have said habeas must be recognized and utilized here, meaning due process has to be given to anyone that they're going to try to use this act to remove. All right. Right, Liz, right. So, and that's what I'm saying. So under the Alien Enemies Act, all right, there is no due process. No due process is allowed. All right. Now, whether or not this is appropriately used because it's a wartime act and those kinds of questions, those are still being debated. Those still have to go through the process. But the due process element of it, that was the restraining order, the reason why the restraining order was in place, the Supreme Court said you have to have due process, even if you're not a citizen. You have to have the ability to have notice and an opportunity to be heard. That's what they're saying here, all right? Again, I'm not saying I agree, but I am saying there that the Supreme Court is holding you cannot remove people without due process. All right? Due process. It is kind of huge. Yeah, that is a really big deal. It's not great. This whole thing isn't great, but this part is pretty huge. Doesn't Congress have to approve the Alien Enemies Act? Right, and those questions need to be answered. The whole issue of using the Alien Enemies Act needs to be answered through the court process. The judges need to go through and answer. These are where we have legal arguments. The judges bring in the precedent and then they make a decision. That has to be answered. But until that's answered, no one can be removed using the act without due process. That's what they're saying. Okay, that's what they're saying here. That's what they're saying. By the 20th. All right. All right. Yeah, I believe you. What about the people in the prison already? Can they get their due process? That's a really good question, Ashley. It's not going retroactively. The restraining orders that have been revoked by this order that just came out, so those temporary restraining orders, only applied to any new people. So anyone after the order was in place. So the ones that are already there are not covered by the restraining order. That's going to be a different bag of worms. Like can of worms? Bag of beans? I apologize, everybody. I apologize for that. Right. It's very confusing. It's incredibly confusing. Driving me nuts. How they sleep at night. I don't know. They're probably medicated, is what I'm going to say. Didn't they still grant due process to... They certainly did, Ryder. They certainly did. 75%. Oh, yeah. Oh, no. No, that's not right. No, that is not what I was saying. Can of beans, can of worms, bag of beans. I'm sorry, everybody. All right. Yes. So let's take it from the top. Let's review. All right, everyone. Here we go. We had a case that just came down per curiam from the U.S. Supreme Court on the JGG case. So this is the overall case involving El Salvador. So under this case, we have the Alien Enemies Act, right, where they're trying to use this wartime act in order to just put people on planes and ship them to El Salvador. Now, there's no due process under the act. All right. So they're saying, well, we don't have to give them notice and an opportunity to be heard. We can just put them on a plane and ship them. So a temporary restraining order was put into place by the judge in D.C. in order to make it so that no one could get shipped out under the Alien Enemies Act. Because he's like, dude, there's no due process. We have to have due process. So what the Supreme Court today has done, and there's a couple of legal arguments in here. First of all, this really bothers me. They turned that TRO into a preliminary injunction. All right. I'm not a fan of that, but that's what they did. And because of that, they said it was reviewable by the U.S. Supreme Court, right? They've got to have jurisdiction. Usually the lower courts will have jurisdiction over restraining orders. But here they're like, we're going to turn it with a magic wand into a preliminary injunction. And that means we can review it. It's reviewable by the U.S. Supreme Court. So the U.S. Supreme Court came in and said, well, preliminary injunction, you don't really need that now. Because we went through the factors in the test and it's not appropriate here. But we have to have due process. It does not matter if you're a citizen or not. You must have due process, which means this is a habeas case. meaning bring forth the body, saying you are in unlawfully being detained by the government. So you have a habeas case, and your jurisdiction is wherever your confinement is. All right. So you have to have notice and an opportunity to be heard under the Alien Enemies Act. All right. Before, we had nothing. We had no due process. Now they're saying we're pulling the restraining order because we're putting due process in place. So we're not dealing with the substance or the legal arguments of the Alien Enemies Act. What we're dealing with is, because that has to be argued out in court through the normal legal process. But what they're saying is we have to have due process. Everybody has to have due process. All right. So that is what the court has held. Now, the second part B that was also what we were going through was Mr. Garcia's case, where he had not been justifiably removed to El Salvador, and the government admitted it. There was no legal reason why he was put over there. And so now we are trying to figure this question out because the judge, the DC judge, or the Maryland judge is like, get him back home. Government said we can't. They appealed it to the Supreme Court. Supreme Court said, we'll let you know 5 o'clock tomorrow. All right, that's the quick and dirty update on that one. Yeah. Why didn't they allow home venue? Because the nature of the habeas case, the nature of habeas corpus is saying, I am being detained unlawfully. So really, like the crime, the problem, where that's occurring is where you're confined. The problem isn't your home venue. The problem is occurring in the detention center where you're at, is the rationale. Again, I'm not saying I agree. I'm not saying I'm okay with any of it. I'm just explaining what it means. Jeremy says, oh, you're so sweet, Rihanna. Oh, that's so nice. Yeah, they do. They've been moving him around. Mr. Garcia was moved around over and over and over again. What does habeas corpus translate into? It means bring forth the body, essentially. It means I am being held by the government unlawfully. I want to see a judge. So it's your way of being able to see the judge, to be heard. So it's a notice, opportunity to be heard. Due process is a key piece under our habeas law. Just gave me hope. Oh, we're going to get through this. This is awful. This is awful. This is definitely a historical moment. And the most important thing that I think we can do is learn about what's actually happening and remember. We can't sweep it under the rug. I think it just has to be brought to light as much as possible. This will slow the administration down. Will they look for other ways to bypass the law? I think both. I think it'll slow them down to some degree, because a notice and an opportunity to be heard slows everything down. That's why they didn't want to do it. That's why they were using the Alien Enemies Act, because they could do it quick. They wanted those quick, fast, big numbers, that shock and awe, because it's not, so exciting to be like, okay, we've got another habeas hearing coming up. That's not as exciting, right? They just want to put them on the planes and ship them away. That draws the crowds and the numbers. So habeas proceeding, technical constitutional questions, that's, it's a little different. So that's going to slow things down. But on the other hand, they're already looking at ways to get around it. And the judge in DC, I think, said it best. He's like, you've got all kinds of ways to deport people. Just don't do it under this act without due process. Will institutions break down before the courts can catch up? That's a tough question. I would say no. I don't think so. I don't think we're going to have a full breakdown. I think what's happening is the slow crumble. Like rather than, an explosion, what we're seeing is just like the slow, like tipping over, right? The Austin Powers moment when the steamroller's going over and he's like, stop. And it takes like 5 hours. That's what we're seeing with our institutions as well. The efficiency, which I think is hilarious. The efficiency that we had before is fading. But I think our courts will absolutely be able to take control of the situation. They already are. If the jurisdiction in El Salvador, what court ensures due process? So whichever court the lawsuits are brought in is the court that determines due process. All right. So what they're saying here is if you bring a habeas case, so if you, I had read through some of the sworn statements of people in Pennsylvania. There's all kinds of detention centers all over the U.S. So that's where you would bring your habeas case. That's the court that would have the jurisdiction. Yes, due process. You have due process even if you're not a citizen, and that is set out in the Supreme Court's decision today. All right, so anyone subject to this act is entitled to notice and an opportunity to challenge their removal, and everyone should challenge their removal, saying that this act is not appropriate. It's unconstitutionally being used here. And more importantly, the Fifth Amendment entitles aliens to due process of law in the context of removal hearings. You are entitled to due process here. Blah, 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 blah. Very important. Detainees are entitled to notice and an opportunity to be heard. You have due process rights. So the Alien Enemies Act does not have a mechanism for due process. The Alien Enemies Act says the president can just pick you up, put you on a plane, and kick you out. And what the Supreme Court said here is no, you have to have due process. All right? What about the ones in El Salvador? Yeah, that's a mess. It's a mess. Use due process, not some dude's process. Oh my gosh, Jason. That's the best line ever. Oh my gosh, yes. Yeah, that's part of it, is that they're paying to keep Mr. Garcia there, right? That's part of the issue here. So they do have rights to legal assistance. So they're not just I'll tell you right now, the people in the detention centers, we have like, oh my gosh, if there was like a Peace Corps made up of attorneys, like that's them. Their people are there. The attorneys are there. They're like the ones where we've always wanted to help. This is why we went into law. They are there right now. So pro bono filings left and right on all of these cases against the administration. The ACLU's in there. The the People for Democracy's in there. They're all of them. They're all there. They're going in. We're infiltrating all of these different areas for all of these lawsuits. So without a doubt, I'm not saying that they're getting paid or that they have enough resources or that they've slept in the last week, but they're there at least. Did they answer the legality of him using it? No, the court specifically said, we're not here to answer that question. That's what the court process is for. Like, we haven't even started getting to the actual issues in this case. The only thing that we've worked on is to make it stop so that we can go forward in the court. Lawyers Without Borders. That's right. Lawyers Without Borders. So they granted the request. Now, that sounds really bad that they granted. So now the government can just take everybody on planes and send them away. No. What they did was they revoked the temporary restraining orders because they were claiming it's a preliminary injunction that was no longer necessary because the issue here is no due process. And the court is saying you do have due process. You have a habeas case here. So because the court is saying we are putting protections in place, you no longer need that temporary restraining order on the basis of what you had it on before. All right? Did everybody follow me that? Everybody follow that? Does this negatively impact people trying to file in groups? No, I don't believe so. Because hold on a minute. Hold on. I said that too quickly. There are some problems when it comes to habeas with the groups, but I think the extra hoops are, something that everyone knew was coming anyway because of how JG's being fought so hard on the habeas issue. They should have been in place in the first place. Exactly, Barbara. That's exactly right. No, we're there. Why did Garcia? Or why did Roberts issue a stay in the Garcia case? So I think what's happened for Garcia, he's given an extension, is because from what I saw, they need a little bit more time because we are in a brand new territory, of course, and they wanted a little bit more time for everything to get briefed, but not so much more time that, it was out of line. So I think he's wanting more information. So that's why he pushed the deadline. That's my best guess. It could be something else. You think the ACLU will file a class action suit for the men to get due process? Already have, and that's what we're dealing with right now. Yeah. Oh yeah, the ACLU's in there. Yeah. The new deadline, 5 p.m. Not Eastern. Well, it is Eastern. Sorry, everybody. 5 p.m. Eastern tomorrow. Taxpayers paying for those in prison. Yes. We're paying millions of dollars. But it could have been more than that had we sent them to another prison that had, more humane capabilities. I don't even know what to say about that. It's pretty bad. Yeah, it's pretty bad. It's bad all the way around. Yeah, $6 million. $6 million. That's apparently the price. The price going. So hopefully now this has clarified everything, because that came down real fast, everyone. I mean, I literally just printed it while we were still on the live and read through it here. So it came down fast, but I can tell already there's going to be a huge misunderstanding about what has just happened out of the U.S. Supreme Court. But everyone here, you know what it means, right? Be tried in the ICC. I don't know. That would be a bit of a stretch. That would be a pretty big stretch. I think there's worse things than this. There's probably, I don't doubt it's being looked at, but as far as actually going forward, I doubt it. Thank you for walking us. Of course. I'm hoping this helps, because I myself just about fell out of my chair. I think somebody made the comment like, "Oh, the Alien Act is going to be used now." I'm like, I fell out of my chair. Yeah. Thank you for clearing. Yes, I understand. That wasteful money. Oh, exactly, Cynthia. Or how much is costing the DOJ to fight all of the cases regarding Doge. Or even how much they're having to spend to work with FOIA. Even that is like, gosh, the money is ridiculous. As a win for the administration. I don't think it's a win for the administration. I would not call it that. And I've seen some wins. We've had a couple of wins here for the administration over the last few days. Over, Thursday, Friday, there were a couple of wins, some big ones, especially with the Wilcox case, in my humble opinion. But this is not a win for the administration. This is an announcement that even if you are not a citizen, you're entitled to due process. And they're saying, well, now you can use the statute. And it's like, well, you couldn't use the statute before because you didn't have any due process. Part of that due process is determining whether or not you're being pulled in and deported under an appropriate law. Rope. Well, could be. I wouldn't say that's bad. Watching Aaron Parnas can freak you out a little bit. Is he the one that says breaking news all the time? Oh, my gosh. He made a post the other day where he was talking about how his sour gummy candy wasn't even keeping him going. And he's like, I'm so exhausted. Even the gummies, the Sour Patch, gummies. And I felt that, in my soul, I felt that. There comes a time when even the Sour Patch Kids aren't going to be able to give you a pickup. I felt it. I was like, Aaron, I hear that. I hear that. Oh my gosh. Yes, this will be up on my tube of you, and I will post it actually as soon as it gets processed. I will post it. So tonight I will have this up and running just to make sure everybody understands what's going on here, because this is, freaky. Yeah, well, I tell you, yeah. So again, the news, everybody, right? If it bleeds, it leads. That's the news. So I'm not the news. I'm just an attorney sitting here reading documents. So it doesn't matter to me if it's bleeding or not. I'm going to still talk about it. So does this mean the government must bring charges to each person in the USA court and bring them back? So Right. The decision today from the Supreme Court has to do with the restraining order for anyone moved after the court hearing. So the people already there are going to have to take different roads. And there are roads for them to go down. Painful roads, but roads for them to go down in order to come back to where they were before. But the rules here, what we're dealing with here, is anyone that was moved after that court decision, of which there was none. 5 p.m. tomorrow, yeah. Well, I don't know. I don't know if they'll ignore it. I mean, there's no way to know at this point. There's no way to predict anything anymore with this one. Rubio's sweating. He should be. Rubio, I got words. That guy's an attorney. And, for shame, Rubio. Like, I supported you when you were drinking that water. I said, oh, don't pick on Rubio. We all have to drink water. And look at what you did. That's how I feel about that situation. I'm like, you need to do that, man. Oh. Okay. Also an attorney, young one. Yeah, no, I think he does. I think he's great. I enjoy listening to Aaron. I enjoy it quite a bit, so I've got no problem with the Aaron. What's the worst case scenario for tomorrow? I would say, oh gosh, that's going to be tough, right? So does the government have to bring back someone that they ship to another country? So I don't know. It's too disturbing for me to even go down that road. It's just too upsetting. If the Supreme Court were to come back and say, we no longer have jurisdiction over someone who's only supposed to be there for a year under the agreement, like who has jurisdiction then after a year? I really cannot see how they're going to untangle this, honestly. TRO just sounds stronger than a free. It does. It really does. It's on our side, making sure we get. Yeah, I appreciate it. 100%. Yep. Yeah, exactly. I mean, it's very distressing. Yeah, no, of course, they sold all of them. They were all sold. We moved into the 8th Amendment. Well, and you're not wrong. I can't come in here and say like, no, it's not the 8th Amendment. No, that's not true. I think the 8th Amendment is absolutely in play here, but an 8th Amendment issue argued is going to take like 6 years. And in 6 years, what's going to happen? I can listen to you all day. Oh, that's so sweet. You need to tell the people in my house that. You need to tell people in the house. Oh, yeah, Barbara, I agree. That's exactly what it is. Nope, we're not at war with the Venezuela. Nope. This is SCOTUS. Yeah, this just came down like, I don't know, a couple hours ago. This particular one. Yep. Congress need to approve spending. I'm not sure exactly how the money went. For all I know, all of the money that was supposed to go to cancer research, they just put in gold bars and gave to El Salvador. I have no idea. That's how crazy things are right now. They're like, okay, money for school lunches, we need that. Cancer research, we need that. Anything else? Nope. Okay, give it to El Salvador. I have no idea who exactly will be defending the Penguins, but I know somebody will. I have no doubt. Okay, yeah, we're not at war. I mean, we've got I think there's 5 countries that are our arch nemesis or nemesi, but other than that, yeah, we're technically not at war. Will this affect his case? I don't believe so. I don't believe this will negatively impact the case going forward, right? And again, the temporary restraining order, the point of that was to make everything stop until it could be processed through the courts. Because what they were doing before was not even giving anybody due process. So now the court's saying you need to have habeas. Now, whether or not that a Texas court who is going to be seeing that habeas situation moves appropriately, that's another question. I mean, good Lord help us all. But at least at this point, we have due process that has to be acknowledged. So questions have to be asked and answered. Yeah. Now, again, I don't know how things are going to shake out in Texas. I know. What are the Penguins going to do without their... Oh, I know, right? I know. How can El Salvador hold... Right. That's a great question, and I don't know. And I really don't know. But El Salvador, like, the dude running that country, he's kind of a jerk. Like, I don't want to be rude, but he's kind of a jerk. I mean, he's being pretty, like, funny about stuff. I'm like, this isn't funny. If you think this is funny, there's something wrong with you, dude. You need to go to, like, a class on how to be a human, I don't like to be negative, all right? I don't like to be negative, but I'm going to say that. I'm just going to say I'm not a big fan. Oh, my goodness. Right. Anything for money, and that really changes the course of a lot of things. So, fishy going off the penguins. Oh, my gosh. Oh my goodness. All right. Right. Yeah, so it's suspicious. I would say. Suing El Salvador. I don't know. The Penguin to me was always that guy with the top hat that was, what's his name again? Gosh, I can't remember his name. He's got those circle glasses and he's all like got some Nixon tattoo or whatever, and he's all like, oh, I'm the greatest thing ever. And so I nicknamed him the Penguin. So that's all I can think about when you say penguin. What was his name again? I can't remember his name. This ruling is good. Why did 3 liberal justices not agree? So I'm not saying that this is good necessarily. I'm saying due process is being required, even if you don't have citizenship. First of all, Roger Stone, that's right. Thank you so much. I appreciate that, everybody. First of all, due process no matter what. Now, the liberal judges or the dissents, and the dissent did go on for quite a bit. There's a lot to the dissent here. First of all, we have this issue of turning that temporary restraining order into an injunction so that they have jurisdiction. That's questionable, first of all. So even if they have jurisdiction to hear the case was what they were saying. Second, the other piece of it, they're looking at the intent here. So we have a de facto versus de jure type situation. And they're saying we're not looking to the intent of what's going on. And I think that's a really tricky element right now. So those are a couple of the biggies. And then also the dissent wanted to walk through the history of what's happening in this case and point out, like, this is an extraordinary situation and we don't want to have this kind of stuff going on. So, that was their perspective. I think they have valid points. I think they have all valid points. I'm not saying I agree with the majority, but I do agree due process for everyone. And that's what they're saying here. And they're saying due process is in the form of habeas corpus. Can jurisdictional rulings be appealed? Yes. Yes, they can. Yeah. They're unionizing. I hope so. The Tufts University woman. So you'll have, I don't know the name of I don't know the universities. We've got habeas cases going for University of Columbia. That's a habeas case that's going. We have, I think it's Cheng, Cheng is another one. We have the other one that was taken at the bus stop. We've got all of those cases are up in play as habeas cases. They are running. Yeah, they are running forward. They're moving forward. I am reorganizing the closet docket, everybody, which has the 175 cases against the administration, and I'm putting it in order of what's happening next. So hopefully pretty soon I'll be able to come on and explain that. They moved her to Vermont. So all right. Right. So they moved jurisdiction over to Vermont. So right now we're waiting, and I just read through the docket today. We're waiting on the court to acknowledge that jurisdiction. So we're kind of in this limbo area. But we're definitely better in Vermont than Louisiana. I'm not saying she was in Louisiana, but some of our other habeas cases are dealing with Louisiana. Yeah. Oh, it's awful. It's awful. You have a legal reason to be here, legal and proper, and you're just getting yanked off the streets. They need to get him back as fast as they... Well, right. But that's not going to happen, right? they're saying habeas corpus and due process and why the Alien Enemies Act. Is this case closed? No, not at all. They're saying the Alien Enemies Act needs to be litigated. So this is a question that needs to be answered through the courts. And there's a process that we have for that. There's a process to answer whether or not this is an appropriate act to deport people under, all right? So they're saying that. But the piece of the Enemies Act that doesn't allow for due process, the Supreme Court said, now that's not permissible. That's not allowable. We have to have a habeas situation. Habeas needs to be applicable here. So the part of the Alien Enemies Act that makes it so no due process, forget about it. You have a habeas right to due process. But as to whether or not the act is used correctly or not, depending on all the definitions of, war, I guess, that's to be determined. So that's to be determined. They're determined tomorrow, 5 p.m. They need to have an answer going on that. Is Khalil the woman? So Khalil was the Columbia student, the fella. Khalil was the fella. So afraid the Supreme Court will not follow the law. Oh, absolutely. Well, I can't blame you. This Supreme Court, again, I was on the live when someone said they're allowing for the Alien Enemies Act to be used, and the Supreme Court just ruled it. And I was like, well, I'm not that surprised. I fell out of my chair, but I'm not that surprised. Yeah, the Supreme Court's spooky right now. They're not great. They're not great. They blocked the part that gave the government their most powerful. Yes, exactly. So the government, right. So the order came out, and I don't have it with me here, but in the Garcia case, the order was that they needed to have things done by midnight tonight. All right. That was the order. I don't have it, again, that language specifically in front of me. What the Supreme Court did today, what John Roberts did today, was he said, let's move that deadline to 5 p.m. tomorrow. So, they needed to explain to the court or have him back by this deadline that she had put into place. And the Supreme Court just moved it down the road. Yeah, they're all over the place. I think that's a generous way of explaining it. Yes. Yep. So, right. Hopefully, yeah. How many legal challenges would an administration normally face in court? Well, oh my gosh. I think if you add together, what was I doing? I crunched the numbers the other night, and for all 8 years of Obama and all 8 years of George W. Bush, I think we're about there. So, it's really, yeah. But and I think he's beat his old record. I think he had 160 in his first administration. So he's broken his record. Right. Yeah, I agree, Boxer Mom. But I also think it's interesting, Roberts says there's just no way to know right now. They're bonkers. They're just all bonkers right now. It's a bit crazy. Although Justice Jackson her pen is on fire. She's doing some major work. We love that. I just love to see her writing. She is so incredibly well-spoken and makes it so much easier to understand what's going on. So she has a really good dissent. I recommend everyone taking the time to read it. I didn't tonight because I was just trying to get to the biggest answer to the biggest question on the per curiam. But yeah, she did a great job. Why would Roberts rule to keep the Maryland man? He didn't. What he ruled on was more time in order to get the arguments put together, because he wanted more information, is my understanding. And that makes sense. This is huge. We're talking about foreign nation jurisdiction questions on top of, habeas questions, on top of, due process questions. So this is an enormous case. And so he's like, well, let's give it another day, because he just got it. He's like, give me a little bit more time. But at least it wasn't another month, which it could have been. So I'm not saying it's great. And you would just think that something this awful, they would just say, like, go get him. We'll talk after you bring him back. It seems like that would be the humane thing to do. But we don't deal with humane stuff with the Supreme Court. We deal with, well, let's follow the rules in our ivory tower. Oh, is he safe? No, none of them are safe over there. Time to be an attorney, no sure. True, Alicia, there's certainly no shortage of cases, but I tell you what, the best thing about being an attorney right now is that we don't have to be scared, and I hate to say that, and I try to talk to as many people as I can. People are so scared because of what's happening, because of the law. And as attorneys, like, we know how far things are supposed to go. Now, if they're screwing the law over and they're, being outside of the law, that's going to hurt anybody. But just the day-to-day understanding of how the law works, like that fear, we just don't have that same fear. So that's the best thing, in my opinion, right now. It's incredibly stressful. I mean, the judge just wrote in the Garcia case, it doesn't matter if you're an American citizen or not. They're going to ship you over there, man. Yes, we had a fired attorney who was told not to testify. Yes, and we had another attorney. We've had attorney withdrawings, like left, right, and center. They're like, we've got ethics. I follow the Constitution. They're like, well, you need to get out. So yeah, I mean, it's bad. It's bad business for sure. That's not how it's supposed to be. 500 attorneys are standing together to honor the Constitution. More than that, I don't know if there's like a group that's gathering. There might be someone organizing a thing, but in all honesty, in my state, in my community, the attorneys that I work with in my field, none of them are okay with what's happening. I mean, it doesn't matter which party they're on. None of this is okay. This is a fundamental constitutional law questions. And even if you hate constitutional law, which a lot of people do, has to be my favorite, but they're still like, dude, I mean, what are you doing? Just that basic respect for the law that's lacking. Yes, bar associations can go after, for sure, but they need a complaint. They need something to move them that way. Right. Yep. For sure. Yeah, so I wouldn't say this is necessarily a good time, as far as cases go, because, this is crazy town, but as far as safety goes, for sure. Yeah, so real quick, let me do one more quick review, everyone, and then I'll need to close it down for tonight. But I will be on again. These kind of like breaking news cases or like cases that are just coming down, I do come onto the TikTok to do, but I am on the Tube on Tuesdays, Thursdays, and Sundays. And all of my lives here are put over on the Tube so you can watch the full live. Here, let me just do a summary real quick. We just had a decision from the U.S. Supreme Court, per curiam decision on the JGG case. This is a case where we have a temporary restraining order in place so that the Alien Enemies Act cannot be used. What happened was it went to the Supreme Court, and the Supreme Court said, we're doing away with those temporary restraining orders because you don't need them anymore. They're not, it's not important at a level that you thought it was, because we're moving it into a preliminary injunction, first of all, which is weird. And then it passes a preliminary injunction test, so you don't really need it. At this point, they also are saying you do need to have due process. Everybody needs to have due process. Even if you're not a citizen, you need due process. So anyone who is being pulled in under the Alien Enemies Act needs to be given notice and an opportunity to be heard, and this habeas corpus opportunity. So you have a right to file a habeas action if you are someone who's going to be brought in under the Alien Enemies Act. All right, that's what they're saying here. So that's what the decision was here. Now, I'm not saying it's a great decision, but I am saying the Supreme Court said, if you are not a citizen, you have due process rights. And under the Alien Enemies Act, it's not been decided whether or not this is appropriate. We haven't decided that yet. But so the government can go ahead and use it. and which, that's not great. But what they're saying is if you use it, whomever you use it against has an opportunity to have a habeas corpus filing, right? So the whole system, the whole process gets slowed way down. And you can't just be put on a plane and shipped to El Salvador. So no more of that. No picking up people and shipping them over to El Salvador. You have to have a habeas action. All right. So that's the big piece that came down with Trump JGG. The other case we were talking about was Mr. Garcia, who was wrongfully taken to El Salvador. And this question is going to be another one answered, hopefully, or discussed tomorrow, 5 p.m. by the U.S. Supreme Court. There is something due. Yes, due process for everyone from now on. Exactly. Even non-citizens in the process of being deported, they have the right to due process. And that's what the U.S. Supreme Court has said. That is the thing. They have said you cannot do what was done here. You cannot just pick people up and put them on planes, which is what the Alien Enemies Act's problem was. So when we're talking about this, we got all kinds of issues, right? It's a wartime act. It gives the president power to, kick enemies out, whatever. The big piece here, of course, it's a wartime act, so that's ridiculous that it's being used. But the other piece here is that there's no due process element to it. So you just pick them up, put them on the plane. Now, the process in which this administration's using the act is not appropriate. They have to give them due process. Right. Scared to go outside at this point. I understand. I understand. Yeah, for anybody who is brown. Yeah, brown and black. But quite frankly, this isn't our first rodeo, if you know what I mean. We most of us already have a routine here. What about the ones already taken? That's a different can of worms, can of beans. That's a different situation. They everybody that has been moved over there, we're still trying to get information. The DC Chief Justice is still like, who's over there? How long have they, what's their name? What's the information? The government's like, we don't have to tell you anything. So that's still being fought in court. Thank you, love you. Oh, thanks. Oh, yeah, these are my pirate nails. I hadn't planned to be live tonight. So these are my fun, not going live nails, but there you have it. It's a different can of pennies. That's right. It's an official act to put them on a plane and send them away. I'm not sure. If you mean for immunity, then, you have to have a criminal charge being launched against the president in order for that immunity official acts business to be used. But if you're talking about administrative actions, we go to court to sue them in order to have the action stopped. So we're not coming in here saying, you harmed me and I want $10 million. No, what we're saying here is your actions are unconstitutional. You need to stop them. So this is a different kind of litigation. Yeah. Who's liable if they are? Oh, that's a good question. That's a great question. And honestly, it looks like we do have a little bit of precedent on that. Oh, thank you so much. I appreciate that. That's okay. If your name doesn't match your birth certificate, that's okay. That was a huge scare campaign that was run. It's okay. No matter where you are, if your name doesn't match your birth certificate for anything, you have to do certain things. So it's not just, you just have to make sure your paperwork's in order. That's all. It's okay. You just have to make sure that your paperwork matches. Right? So like if you get married and then or you change your name, then you go to college, right? You have to fill out a whole bunch of different paperwork. Same thing. They can use the Alien Enemies Act. And we're not saying that it's legal. We're not saying that using that is legal. What we're saying is it's being litigated and you cannot use it without due process, which is really the only reason why the Enemies Act was utilized, in my humble opinion, because there's like 150 ways. I don't remember the Paul Simon song, everybody. I just can't remember it. But to deport people, this one was a way to deport them without due process. And so they're saying, no, you need to have due process. So why even use this as a basis for deportation when you can use 100 other things? And that's really, at the end of the day, that's the question. It's like, why are you even using this act when there are so many other ways you can deport people? And we took away the biggest chunk of the Alien Enemies Act was that there was no due process. 50 ways. Thank you, Cynthia. I appreciate that. Oh my gosh. Well, right. I mean, they can try. They can try to use that. Yeah, they can try. What happens if he doesn't use due process? So all right, let's back up the truck. All right. So if they decide to put a whole bunch of people on the plane and send them to El Salvador, claiming an Alien Enemies Act without due process, then, they're going to have the same issue that we're having in the JGG case. All right. So the Supreme Court has held you have to have a habeas right. You have to have notice. So anyone involved in the situation of not allowing notice is violating, the law. They're violating the Fifth Amendment to the Constitution. And when you violate that, then, you get taken to court. Well, I don't know about the DOJ's job to stop it, although valid point, Neve, that the DOJ's compromised at this point. So it's all of the rest of us out there, all the rest of the attorneys. I tell you what, the ACLU attorney, all of the attorneys working in the JGG case, every time they start talking, you can just, I don't know, maybe it's just me, but you can just hear it in their voice that they're just like, this is just bullshit. Like, this is such crap. How is this even happening? There's just like this sadness, bone deep sadness. And we all have it. We all have it. So we all go forward and do the best we can. Courts of enforcement, it's not AG. Yeah, I mean, if there are orders that are not being enforced, then the court can deputize people to go and enforce orders. Sure, but we're not there yet. Does this stop ICE from direct deporting others without court case? Yes, that's exactly right. Because in all of our other cases where you're being deported under the immigration acts, right, you have due process. And then they determine, like, well, you're going to be deported. You're like, all right, well, I went through the process and now I'm being deported. Under the Alien Enemies Act, there was no process. It was like, hey, I'm actually like a citizen here with a wife and kids and, a member of the community. And so I shouldn't be deported. They're like, what are you saying? I can't hear you. You're on a plane to El Salvador. That's what's happening right now. All right. So that's the difference. That's the difference here, is nobody could be heard. No one was given notice in this situation. Oh my gosh, do good attorneys have the endurance? Of course, that's what we're made out of. We're made out of endurance. The other thing too about attorneys is we work hard, but we also, can tag the next one in. So there's an understanding. We work our keisters off as attorneys. That's part of what we do, especially in this area of the law. Constitutional law, human rights, ACLU world, where we're dealing with constitutional rights. I mean, yeah, that's every day. That's just our every day that we're dealing with that. I agree, Bella. And that's really the worst of this situation, is that the system is so slow. In order to make sure mistakes aren't made, in order to make sure all the rules are followed, it's incredibly slow. And then while we're making sure and taking things through the process, an incredible amount of harm is being done to innocent people. And there's no way to ever undo that harm. And it's heartbreaking. Where can we get a copy of this order? Right. So the per curiam case, you can just pull this up online. You go to put this into your search engine and then just say per curiam decision, or alternatively, you can just put this number in and it'll pull the case up for the Supreme Court. You bet. Yeah. Oh, yeah. I mean, yeah. We don't, Lisa. We don't have confirmation of that. We don't. And honestly, depending on who's in there with him, if they were the ones going after him before he came to the U.S., I have no idea. It's a pretty bad situation. One that will be one of the worst that I've seen. And I've seen a lot of really bad ones. But this one is absolutely one of the worst things I've ever seen done by our government. So with that, my friends, I will go ahead and sign off. I will post this live up on my tube. I'm on the tube on Tuesday, Thursday, Sunday nights at 7 Central. I will also, whatever's breaking news or like the latest orders that come out, like this just came out here, I do those over here on the TikTok. So I will be here if we've got new news coming out tomorrow and various other places. But 7 o'clock Central over on the tube on Tuesdays, Thursdays, and Sundays. And this live will be posted there in a couple of hours. Hopefully this has clarified some things. Feel free to ask comments on any of my posts if you're still wondering about what exactly is going on. So take care, everybody, and I'll be back again very soon. Thank you, moderators, for all of your hard work. So grateful for your time tonight.